Hello, and welcome back to the Very Real Estate Effect podcast, a show dedicated to real estate right here in Quebec. So, today I am very pleased to have David Ghavitian, a lawyer, here with us today. Hello, David.
Hi, Axel. How are you?
I'm doing super good. Look, I'm really excited that you're here because I've been getting a lot of questions when it comes to partnerships and structures and how to do it and what documents do I need. So, I just thought, you know, what a better person to ask than you, who's a specialized real estate lawyer.
Sure, it would be my pleasure to go through the whole process with you and educate your audience as far as what the proper structure should be when looking at an investment property.
Yeah.
Absolutely.
Okay, perfect. So, you know what? I'm just going to start with like a really easy example. Let's say I'm looking at a property right now. I'm looking at, I don't know, a 12 unit. I want to buy it with a partner and I'm going to do all the work. He's bringing in the money. Basically, what would you recommend? Like, how should we go about it?
Well, as a general introduction, for anyone who's looking to build wealth, achieve financial independence, or even retire early, it's important to build streams of passive income. That's where real estate comes into play. And one of the most popular methods of building passive income is to purchase a property that generates that rental income. If done correctly, and with some luck, the return on investments, or as we use that keyword ROI, which is composed of both rental income and appreciation in the value of the property, it can significantly improve your net worth.
Hmm.
An important decision that a lot of my clients face when purchasing a rental property is whether you should own the property in your own name or purchase it through a corporation.
Yeah.
The right decision depends on many factors, which I'd be more than happy to share with you today.
Yeah, absolutely.
The first question I always ask my clients, whether it's a rental, it's an investment property or not, is if they're using part of it as a principal residence. Many owners have a rental property that is part of their existing home in the form of a duplex, a triplex, or even a sixplex where they'd be renting out they'd be occupying a certain component of it.
Hmm.
And in that case, it probably doesn't make sense to incorporate it if you're using it as a principal residence, since you risk losing your principal residence exemption,
Yeah.
which can have a significant impact on tax savings or on the appreciation of the value of the property on its eventual sale. And the
Hmm.
reason why I state that is that the principal residence exception in Canada allows you to sell your home without paying any tax on the capital gains. So that's one of the things that I look out for when it comes to buying a property, whether it's for an investment or if you're using a certain component of it to live in yourself.
Hmm.
Um, Second of all, if you decide to purchase the property with someone else, even including a spouse, it might make sense to incorporate, as this gives the co-owners or the partners a separate legal entity that gives clear beneficial ownership in the corporation based on whether the proportion what the proportion is that is decided on the outset. For example, if you have two co-owners who decide to contribute to an equal portion of the down payment, then the ownership percentage should be normally allocated at 50% each.
Makes
It is
sense.
important to draw up some sort of a partnership agreement between co-owners that outlines the percentage of ownership and which handles also the different management aspects of the company. How any major repairs come down the road will be handled, who will pay for them, who will take care of the accounting and tax reporting, and etc. As far as the legal perspective as to why you should incorporate, there's always a risk involved when buying a property. There's usually a risk of litigation, lawsuits, getting notices from the city with respect to something not being conformed with the property. And that it may make sense to incorporate to provide that limited liability protection.
Hmm.
So if Axel and David are buying a property together and we're incorporated, what would happen is that that company, which would own the property in itself, would have its own separate and distinct legal entity,
Correct.
and it would be separate from our personal liabilities as well as yours.
Hmm.
Normally, the only way to go through the company and hit the shareholders directly themselves are in elements where there's fraud involved. In cases like that, where they can go after the shareholders themselves. But
Okay.
normally, the biggest advantage to having an incorporation done is to separate your legal liability from that of the company itself. Before incorporating, it's also important to verify with the seller and bank if there's any restrictions on selling the property to the corporation. That's what I would always check with the client themselves to make sure that everything is nice and steady.
Hmm.
Some properties may be only be sold to individuals, so it's important to verify that with your bank as well as your accountant. A bank may have different criteria with respect to the mortgage financing to an individual versus a corporation, and in more cases may require a personal guarantee. So it all
Definitely.
depends on the strength of the covenants that you were to provide to for the corporation that would own the property in itself. Last but not least, big question that I usually get are what are the costs associated with an incorporation?
Hmm.
Well, there's usually a one-time fee to incorporate
To
and
set
register
up.
and get your GST and QST numbers from the very onset. And then the client or the owner of the property would have an obligation to file his annual returns with the Quebec Registrar of Business, if that's the jurisdiction to which they incorporate, and would have an annual obligation to file financial statements on behalf of the company every single year.
Yeah.
So those are the recurrent costs that come with incorporating a company. And from what I've seen in all my experience, an incorporation is usually the way people buy a property these days.
Yeah. Yeah, definitely. Well, they want to limit the liability, as you mentioned, and protect themselves against anything that could happen. So, a potential legal issue can come after their personal assets. Just
Absolutely.
going back to the cost. So, obviously, like the cost of registering a company, it's what, like $800 to $1,000, or what are we looking at?
Usually to prepare to incorporate a company as well as prepare a minute book, which is an obligation that all companies have, you're looking at a start-off cost somewhere between $700 to $800,
Okay.
and you'd also have to hire an attorney who could do this right. You
Hmm.
know, you can always try to fix a car itself, but if you don't go to a car mechanic, you're going to always end up having problems afterwards. People think that it's usually an easy process, but in most cases they get stuck, and that's why they come to a professional like myself in
Hmm.
order to do that job for them.
Okay. Okay, so now we've talked about like the actual setup. A key element is obviously in doing a partnership is choosing a partner, finding a partner, and I know that we could talk for hours about that. But one of the questions I had for you, because you're really in that field and hopefully preventively putting guidelines so there are no problems. But I'm sure you have a lot of people that come to you with problems in their partnership. And what I wanted to ask you is, what are some of the most common issues that you see happen between partners and how to prevent them?
Oh, perfect. So let's get back to that example between myself and you.
Okay.
If we were to buy a property together. Now, the
Yeah.
most common problem that I see is what happens after they buy the property. And yes, the allocation of percentage of the ownership of the property may already be set out in the beginning, but although we do have rights to the property, we also have obligations that are concurrent to that.
Correct.
One of the most common issues that I see is that a client would come up to me and tell me, "Oh, maybe I didn't choose the right partner because we don't necessarily know what our obligations are, what our duties and responsibilities are." That's where I would recommend drafting some sort of a shareholders agreement that comes hand in hand with the incorporation, which basically, when you're dealing with any shareholder, they have three basic rights. They have the right to vote,
Mhm.
which basically gives the general direction of the company. They have the right to participate in dividends, which is the profits of the company, and also to participate in the dissolution and the assets of the company that come with it. Now, depending on how sophisticated you want to make your company, you can have several classes of shares. You can have Class A shareholders, which, and we're going to deal with this specific right in itself, gives the right to vote.
Mhm.
The right to vote basically gives that, like I said before, the general direction of the company. And you want to make sure that what you're voting on is clearly set and established in the shareholders agreement. So when I am in creating that shareholders agreement, I give a long list of responsibilities, and it's up to the shareholders to decide, do we want more than 50% of the votes to go towards a decision? Are there some decisions that don't necessarily need the voting powers of the shareholders, and do we let the directors handle it? For example, if you want to take out a loan for the property, depending on how much the value of the loan is, normally you would want 100% of the votes of the shareholders to be included, whether or not to continue on with that. In some cases, for example, where there is a maintenance or major renovations that are done to the property, you want the right to vote to come along with that.
Yeah.
Sometimes you have minute issues that don't necessarily need to be in the shareholders agreement, and that's a good thing because there's day-to-day activities and responsibilities towards each company, and you want to make sure that you can be able to just do them without necessarily having to revert to the shareholders agreement. The way I see it and the way I explain to my client is that you only want a shareholders agreement in case something happens between yourself and the shareholder and you need some clarity, because the law may not necessarily be clear as far as what the duties and obligations of shareholders are, but that's why you have a shareholders agreement inside there. There's also specific clauses in a shareholders agreement. For example, if a partner wants to sell his shares, what is the process involved in that? Does he have the right? Do the other shareholders have the right to buy those shares out before selling it out to the public? There's a certain element of control that you want within that corporation, so it's important to set out all those obligations in said agreement. We also have mediation and arbitration clauses inside there, which dictate that instead of going through the long, expensive, and arduous route of going to court, maybe there's a mediation or some sort of an arbitration you could put out there that could help both partners or shareholders resolve their issues.
Mm-hmm. One quick question. When you mentioned the vote, I find that something very interesting that hadn't given much thought to, is that if it's just two partners and so they both get one vote, but if one says yes and the other one says no, how do we choose? What happens?
Well, it depends on the urgency. It depends if there's a shareholder dispute. That's where mediation and arbitration comes into play. There's also the element of going to court. If you're choosing arbitration to be non-exclusive, you can go to court and resolve these issues. So understanding that there's possible consequences to not reaching to a compromise, I think most partners are more inclined to sort of resolve their issues. And that's why I'm saying the number one aspect in having a partnership agreement or a shareholders agreement in an incorporation is to find that right partner, to make sure that your views are aligned. You want to make sure that they're aligned not only on the short term from the day to day, but also on the long term as to how you position this property, whether or not you want to sell it or how hold it as an asset going forward.
Mm-hmm. Okay, makes sense. And I had heard of, I have a friend actually who had set up a company. It wasn't in real estate, it was something else. And he had a partner, and they had agreed that they would both hold 49% of the company, and they had given 2% to a lawyer in case. And they said, if we're stuck, we'll go to him. And I just thought that was a clever idea.
Nah, that's a good idea. Some people may not necessarily want to relinquish their shares to a third party, but if that works for that friend, then all the power to him.
Yeah. Cool. Okay. So now moving along, again, the big mistakes of partnerships, and I'm sure you've seen some crisis in your office of people even maybe I wouldn't say fighting, but getting to that point. Again, how do you avoid it? Yeah, having a clear shareholder agreement, but is there anything else that that partners can do?
Partners can do in respect to what exactly?
Yeah, sorry, in making sure that they've got to know each other, that their vision is more or less aligned, and they do a partnership agreement. Yes, but I'm sure there's still conflict.
There's conflicts which can be resolved by the courts or through any other mediative aspects that they can find there. Normally, sometimes you could revert to the shareholders agreement. You could incline that other person to sell your shares or sell your shares to them, or find some other sort of mechanism. But it's important to find that right partner from the onset.
Yeah. In order to buy each other out, are you referring to the shotgun clause?
shotgun clauses, right of first refusal, drag along. There's so many different types of different clauses that you can use with respect to either buying or selling out your shares, and that's basically what it is.
Could
Very
you
basic as
could
far
you
as a
briefly
shareholder.
because briefly what I had heard, well, I guess I should just wait. No, but I had heard that it was like you value it, I value it. It's essentially like you cut and I choose. It's like, there's one piece of cake left and you're with your brother and you say, okay, you cut and I choose. So then both have the incentive to actually cut in the middle.
As far as the shotgun clause is concerned, what are they and how do they work? If you're purchasing shares in a company, or if you're already a shareholder and are considering implementing a shareholders agreement, one important provision to have is that buy, sell, or shotgun clause. A shotgun clause provides some sort of important leverage to be used in the event that a shareholder, for one reason or another, needs to part ways with the other shareholders of a company.
Yeah.
Specifically, a shotgun clause is a provision in a shareholders agreement which gives any shareholder the right to make an offer to the other shareholders to buy their shares out for a certain amount of money that is specified in that notice that they would send to the other shareholder. And if those shareholders refuse, and this is where the catch is, they are then forced to buy the shares of the shareholders who made the offer for the same price per share and on the same terms.
Oh, okay, that's
So
right. Yeah.
the genius that underlies the shotgun clause is that they compel all sides to be reasonable,
Yeah.
as a bad or unreasonable offer can easily turn off the offer, leading them to be forced out of the company.
Yeah. Yeah. It's actually a very good fail-safe. Like, so essentially, to make it simple, you and I have a building together. I want to buy your shares, and I make you an offer at 400,000. You say no, then I'd be forced to actually sell you at that price.
Exactly.
Yeah, that's very good. That's a good.
Yeah. So that's one option that we would have towards resolving issues between, shareholders who may not necessarily get along on a specific subject.
Okay. Okay, that brings a little bit more clarity. In I find like selecting the partner is so important, and obviously setting up all of the legal rights and responsibilities, as you mentioned, is a very interesting exercise because most people at the beginning, it's like, oh, it's nice and dandy, we're gonna go buy something, but then when the work actually needs to be done and people start to chicken out, that's when you start to see the real people and the real personalities, and it's like, oh, I don't
Oh
want to
yeah.
do this. Yeah, but it needs to be done. Well, I don't want to do it. Okay, but we're in a marriage here, and I
It's a
have.
marriage. That's exactly the right
Yeah,
word. You're getting into a relationship with somebody.
that's it.
Make
And
sure that you can get along with them from a good business perspective.
exactly. And I've read this quote and I found it absolutely love it. So I'm gonna give it back, which is that if a partnership in real estate is like a marriage, then make sure you date.
Before you get married.
Absolutely. Go out for dinner. Go look at problems together. Go talk to people. You'll see how they react. And I just thought it was such a good way to put it. And anyway,
You
just
know, it's
wanted to
funny.
share it.
That's what one of my biggest clients told me about a decade ago when I started working with them. I wanted to obviously take over all their files because they have thousands and thousands of doors, and there's some good opportunities to do some business there. And I was so gun ho about, okay, you were giving me this file, but how about this and that? And he
Yeah.
gave me that exact quote: "Before we get married, let's go on a date."
Let's go on a date. Anyways, I love it. Um,
Yeah,
it's so true. It's true for every relationship. And take the time at the beginning because I've seen people like four guys wanting to buy a property and then they couldn't even take it to a close because they disagreed. And I'm like, well, the writing was on the wall. Like maybe it wasn't meant to be. So,
a shareholders agreement is usually there in case
mhm.
something happens. You're not buying a property so you can enter into a shareholders agreement, but
No.
it's always good to have it as a failsafe in case any issues arise later on,
Hmm.
just for smooth sailing.
Yeah. Very good. And I'm sure that's kind of your bread and butter. Do you do a lot of shareholder agreements?
Yes, if I see that there's more than 2 to 3 investors in a specific property, I usually would recommend a shareholders agreement, and I would promote exactly what we're talking about today.
Hmm. Well, look, David, thank you so much for all the information here. And I know we could keep talking about this for about 2 hours, but we also have to be reasonable. And hey, where can people find out more about you?
Oh, definitely. I have my website, which goes by my name, www.davidghavitian.com. I have a phone number, 514-882-2920. I'm pretty active on social media, so people can follow me on LinkedIn and Facebook, where I talk about general subjects concerning real estate law, including stuff regarding shareholders and shareholders disputes. So it'd be my pleasure to help anyone that comes across any issue.
Okay, perfect. And it's a great idea to having some of those contents and conversation on Facebook, so people can go and just read about it. And it's a great way to find out more about you and reach out if need be.
Definitely, Axel. Thank you.
Yeah. Hey, David, thank you again. I always love these conversations because every time I learn just a little new thing. And so that's exactly what happened today. So thank you very much.
With pleasure.
All right, and for everyone listening, thank you again for tuning in this week. As usual, if you like it and if you want to keep supporting us, please subscribe, share it with a friend, send me some feedback, send me some comments, ask some questions. I'll be more than happy to answer them and get in touch with you. So thank you very much, and talk to you next week. Bye bye.